much about Yarif Yarif. Yarif Yarif, Professor Salim Faruqi had once stated that a good constitution must be aspirational and must contain seeds of change for a better tomorrow. We came upon this honorable court today and hope this
No,
court will protect.
say it slowly. Say it slowly. You're too fast. You want to make an impactful statement. You must say it slowly.
Yarif
Don't
Yarif.
rush things.
Start over again. You don't say it for the sake of saying it, lah. If you want to say it to give impact or give impression, say it with conviction, lah. Don't rush it. Start again.
Before I proceed with my submission, may I confirm whether my voice is loud and clear?
You already asked this just now. Don't need to ask it again. Proceed.
Much about Yarif Yarif. Yarif Yarif, Professor Salim Faruqi had once stated that a good constitution must be aspirational and must contain seeds of change for a better tomorrow. We came upon this honorable court today and hope this court will protect the two innocent and vulnerable children in our current case, which will grow into the future leaders of Malaysia. May it please this honorable court. My name is Nicole Ghazali, appearing on behalf of the appellants, Saifuddin and Rena Harun. Together with me today is my co-counsel, Mr. Ng Shin Yang, as well as the learned senior federal counsels representing the respondents. Today, I shall reserve 20 minutes for the first three issues, while my co-counsel shall reserve 21 minutes for the remaining three issues. We will also reserve 4 minutes for rebuttals. Yarif Yarif, before I address my issues, would the court like to be furnished with brief facts of this case?
Yes.
Yarif Yarif, the case upon us today is the joint appeal relating to the same subject matter of citizenship. The child in the first case is Dina, who was born to a Malaysian father before the marriage of her parents. Dina had been issued a birth certificate which clearly records her as a Malaysian citizen until this birth certificate is revoked after a long period of 12 years later. While the child in the second case is Buwen, who was born in the United States in the year of 2021 to a Malaysian mother. Yarif Yarif, I shall now address my issues. I will be submitting on the first three issues. Firstly, a child with a biological father is indeed entitled to citizenship by operation of law pursuant to Article 14(1)(b), with Section 1A of Part 2 of the second schedule. Secondly, the subsequent legitimization of the child indeed satisfies the requirement of legitimacy. Thirdly, Section 1E of Part 2 of the second schedule indeed operates to confer citizenship to a child born illegitimately to a foreign mother but presently does not possess any other citizenship. Yarif Yarif, I shall now proceed on my first issue. Our stance is that the first issue shall be answered in the affirmative and we support it using two grounds. Firstly, Section 17 of Part 3 of the second schedule is applicable only when the identity of the biological parent is in issue. Secondly, the child in this case, which is Dina, had indeed satisfied the two requirements of jus soli and jus sanguinis. Yarif Yarif, with regards to the first ground, we would like to highlight that the federal court in the case of CCH had expressly adopted the minority judgment in CTAB in interpreting Section 17 of Part 3, whereby the court had interpreted Section 17 as a supplementary provision which functions to fill in the gaps only when there are technicalities with regard to the identity of the biological father.
No, I'm just putting some notes. You proceed. Don't need to look at it.
Yarif Yarif, we do understand that the facts in the case of CCH is different with our current case, whereby the case of CCH concerns about abandoned children, Nevertheless, we would like to highlight that when CCH adopted the minority judgment in CTEB, it had included the entire paragraph which held that Section 17 until Section 19B of Part 3 of the second schedule is supplementary provision which only fills in the gaps when there are technicalities in identifying the biological parent. Therefore, we
So what is the gap here in identifying the biological parents for Dina?
It is our submission that the biological parent of the child, Dina, is identifiable in our current case, which is our appellant today, Saifuddin. Therefore, it is our submission that there is no need for us to apply Section 17 in our current case. We understand the respondent's concern and the respondent's stance is that to include the word lawful in interpreting the word parent under Section 1A, which imposes a requirement of legitimacy on the status of the parent. Nevertheless, we would like to highlight that federal constitution is always a living document and it shall be interpreted in a broad and liberal manner instead of interpreting it in a narrow and pedantic manner, especially so when interpreting constitutional provision with conferred rights.
What's your basis in saying this?
This is the decision by Justice Gopal Surya in the case of Sukma Dawawan.
Federal court decision?
It is a court of appeal decision.
So a court of appeal decision say what should the federal court do in interpreting federal constitution?
We do understand that this court is not bound to a court of appeal decision. Nevertheless, we accept that. We would like to highlight that this is always a basic way of interpreting the federal constitution because we're interpreting constitutional provision. The constitutional provision shall be interpreted broadly so as to safeguard the rights of the citizen as well as the well-functioning of the federal constitution, while limitations on such fundamental rights shall be construed narrowly. If we are to
not necessarily, because the late Justice Gopal Siram is a living constitutionalist, all right? So he interprets the constitution in that manner. But there's also interpretation from the framer's perspective, means the originalist interpretation. So what do you think? That brings me to my question. What is the intention of the framers when Section 17 Part 2 was adopted in the second schedule? That may allow us to understand the historical aspect of that particular provision.
The court, the framers who are interpreting Section 17 does not really include their intention of whether Section 17 is to be applicable or is to impose a requirement of legitimacy. Nevertheless, if we are to impose a requirement of legitimacy based on Section 17 onto Section 1A, which is to include the word lawful into the word parent as to construe parent as to being lawful parent, it is our submission that it would constitute a discrimination, and we base our argument based on the minority judgment in CTUB, whereby Chief Justice Tengku Maimon highlighted, if we are to impose a requirement of legitimacy based on Section 17 onto Section 1A, it would create a discrimination between Malaysian father and Malaysian mother, whereby a Malaysian father is unable to confer citizenship to an illegitimate child, but Malaysian mother is able to do so, pursuant to Section 17. Therefore, such a narrow way of interpretation is clearly discriminatory against the rights of the father and rendering the citizenship of the father valueless. Therefore, we would like to submit that by all means, Section 17 is inapplicable in our current case, as Section 17 is not imposing a requirement of legitimacy, as well as it is a supplementary provision which will only be applicable when the identity of the biological parent is unknown.
When you say that the federal court in CCH adopted the minority position in CTEB, are you saying that CTEB has been effectively overruled by this court?
Eric, we ask for clarification because
Okay, my question is, when you say that this court in CCH has adopted the minority decision in CTEB, does it mean the CTEB has been effectively overturned by this court in CCH?
Eric, the court in CCH did not expressly state that the judgment in CTEB had been overruled. Nevertheless, we would like to highlight that since CCH is a more recent decision than CTEB, therefore we would like this court to consider CCH as well. Eric, pursuant to that, we shall look into Section 1A of Part 2 of the second schedule. It simply provides that citizenship by operation of law is to be conferred on the person who was born within the federation of whose parents one at least is at the time of the birth either a citizen or permanent resident in the federation. Therefore, this provision clearly anchors the two very basic elements of jus soli and jus sanguinis. The Chief Justice in CTEB had held that if we are going to disregard the biological nexus between the biological father and also the biological child, just because there is a lack of a legally recognized marriage, it was going contrary and defying the very notion of jus sanguinis, which means transmission by blood descent. Therefore, we would submit that Dina in this case had fulfilled the two elements of jus soli and jus sanguinis, as she was born in the Federation in Kelana Jaya Medical Center, fulfilling the element of jus soli. And secondly, her biological father is identifiable as a Malaysian citizen, which is our appellant today, Saiful. Therefore, it is our submission that Dina is indeed identifiable as, my apologies, it is our submission that Dina is indeed entitled to citizenship by operation of law pursuant to Section 1A of Part 2 of the second schedule. Yarif, I shall now proceed to
Also, before you proceed, you are saying that Section 17 of Part 3 of second schedule is inapplicable because the biological father here is known, is it? That's your basis, right?
Indeed, Yarif.
So if that is your basis, then can you explain to me Section 17, it says that person who is illegitimate to be construed as reference to his mother, then who will fall under illegitimate in this case?
Yarif, we will submit that a person that will fall within this Section 17 is a person whereby who has a foreign mother, for example, who had been abandoned by a biological father of Malaysian citizenship, and therefore the identity of the biological father is unknown, and thereby
But you already said abandoned by a Malaysian father, so the father is already known, correct? In that case, every instances, if I can prove that the father is a Malaysian, Section 17 won't be applicable at all, because you are trying to preclude lawfulness into marriage, in giving citizenship into a children. You get what I mean?
Yarif, let me reconstruct my answer quickly. Section 17 would be applicable for children who was born to a mother who was either a Malaysian or a foreigner. However, the identity of the biological father is unknown. For example, when the mother had been abandoned by the father.
Okay, proceed.
Yarif, assuming that the first issue is answered in the negative, we shall now proceed to the second issue. It is our stance that the second
Before you
issue...
move into the second issue, right, it seems just a question on locus standi, right? What's Saifuddin's locus standi here? Huh? Because I think the dispute is in connection to the registration of the children itself, not him.
Arif, we would submit that Saifuddin has the local standard to claim upon this honorable court today for that he is seeking for a declaration that his child, which is Dina, is entitled to citizenship by operation of law in our current case.
Shouldn't the case be filed by the individual who is challenging her citizenship instead of Saifuddin? Because he's a Malaysian citizen already, ma.
Arif, may I seek for clarification for this question?
Shouldn't the applicant in this case be the person where his or her citizenship is in question instead of a third party?
Arif, we will highlight that when this case has been filed in the High Court, the child in this case is still a minor. Therefore, as a legal representative of the child, which is the appellant today, Saifuddin, we submit that Saifuddin indeed has a local standby to
Okay, proceed.
Yarif, our stance that the second issue shall be answered in the affirmative, for that an illegitimate child who had been legitimized by Section 4 of the Legitimacy Act indeed satisfies the statutory requirement of legitimacy. Yarif, we appreciate that the Court of Appeal in the case of Madhuvida had highlighted that Section 17 is drafted in the present tense, whereby only a person who is illegitimate had the word parent to be construed as references as to his or her mother. We do understand that this Court of Appeal case had been overruled by the majority judgment in CTEB. Nevertheless, considering that Madhuvida is one of the rarest cases that explain the grammatical construction of Section 17, we humbly and respectfully request this Honourable Court to consider and look into this case as well. Yarif.
Tell us briefly what happened in this case.
Yarif. The court in Madhuvida, the case happened in Madhuvida is that is similar to the facts of this current case, whereby the appellant, which is the child in that case, was born prior to the marriage of her parents as well, and her mother in this case is the mother of a citizen of Papua New Guinea. Therefore, in this case, the court had held that Section 17 is inapplicable because her parents had subsequently married after the birth of the child. The Court of Appeal had raised their reasoning based on the grammatical construction of Section 17, which refers to a person who is illegitimate, had the word parent to be construed as to her mother, and therefore the court had held that since the child in that case is already a legitimate person, Section 17 is inapplicable to her. Similarly, in our current case, the child Dina was indeed born illegitimate. Nevertheless, she is legitimate at the current moment because her parents had subsequently married to one another in the year of 2005. Therefore,
Based on what law, counsel? What law are you basing on?
Yarif, pursuant to Section 4 of the Legitimacy Act, an illegitimate person would change his or her status to a legitimate person.
Do you have the provision with you, verbatim?
Yarif. Yarif, please give me a moment. Yarif, if I may read, subject to Section 3, where the parents of an illegitimate person marry or have married one another, whether before or after the prescribed date, the marriage shall, if the father of the illegitimate person was or is at the date of marriage domiciled in Malaysia, render that person, if living, legitimate from the prescribed date or from the date of the marriage, whichever is the later. Therefore, Yarif, in our current...
What does legitimate, counsel, what does legitimate here means in this provision?
Yarif, with regards to the word legitimate, it is our submission that the word legitimate person had been defined in Section 2 of the Legitimacy Act, which means a person legitimated by this Act.
Legitimated, any means?
Legitimated by this Act or any of the written laws. This is the definition given in the Legitimacy Act.
You are saying that this child is no longer illegitimate because the parents were married after she was or he was born, correct? That's your basis.
Indeed, Yari.
Then what is there any difference in terms of lawfulness and legitimateness of the children?
Yari. We would like to submit that there is a difference because pursuant to Section 17, if the person is still an illegitimate person, indeed her citizenship would be referred to as to her mother. However, since in our current case, the child Dina is legitimate at the current moment, therefore her citizenship does not need to refer as to references to her mother under Section 17. And that is why she is entitled to refer her citizenship as to her Malaysian father in our current case.
Okay.
Yari, I shall now move to my third issue. Yari, I see that my time is up. Could I seek for an extension of 3 minutes to sum up my last issue?
Yes.
Yari, with regards to the third issue, we submit that the third issue shall be answered in the affirmative, such that a child who presently does not possess any other citizenship is entitled to citizenship by operation of law under Section 1E. This is because a child would be a stateless person if she was not being conferred Malaysian citizenship in our current case. Yari, with regards to that, we shall now look into Section 1E of Part 2 of the second schedule. This provision clearly confers citizenship by operation of law to a person born within the Federation who is not born a citizen of any country. Yari, the term not born a citizen of any country had been explained by a High Court case named Ong Sing Tong, whereby in that case, the High Court judge had interpreted this phrase as such that a person must have already acquired citizenship of another country before he or she is not entitled to come into Section 1E. With regards to what is meant by citizenship at birth, we can refer to Section 2, Clause 3 of Part 2 of the second schedule. In Section 2, Clause 3, it has stated that citizenship at birth refers to citizenship that the person acquires within a period of 1 year. Therefore, Yari, in our current case, Dina had at all times been recorded as a Malaysian citizen since her birth. Hence, it is our submission that by all means, Dina did not register herself in Indonesia and thereby she did not acquire Indonesian citizenship in our current case. Hence, she is a stateless person in our current case if she did not being conferred Malaysian citizenship. Yari, if I am of no further assistance to this honourable court, I shall subsequently yield this floor to my co-counsel, Mr. Ng Chun Yang, to submit on the remaining 3 issues. And we respectfully request this honourable court to declare that Dina is entitled to citizenship by operation of law under Section 1A or Section 1E for her to continue living in Malaysia, continue her education in Malaysia, and to stay in this country where she already had a strong cultural and emotional bonding. With that, I shall yield this floor to my co-counsel and I thank this court for its time and indulgence.
Just one question, counsel. On your third issue, right? Your argument is essentially whoever that is born in a country, who is not registered a citizen in other country is entitled for citizenship, right?
Indeed, Yari.
If this court were to rule based on what you have submitted, what do you think the impact on our social economy? From an angle of a social perspective, everyone born in the Federation can be entitled citizenship. You know the effect of this ruling that you are asking these courts to rule. Does that make sense?
Yari, allow us to clarify our stance. Indeed, we submit that a stateless person is entitled to citizenship by operation of law under Section 1E. And in order to prove statelessness, we do acknowledge that we need to look into the biological lineage of both parents. However, in our current case, it is our stance that by all means, Dina did not acquire Indonesian citizenship because of a failure to register in Indonesia. because Indonesian citizenship requires illegitimate children born before the year of 2006 to register themselves. Therefore, Dina in this case is a stateless person because of this, and because of her failure and failure to comply with Indonesian citizenship law, and therefore she is stateless in our current case. Hence, we do acknowledge that there is a high threshold to prove statelessness, and thereby we submit that this Section 1E would not induce too much of a social problem, as it is still a high threshold, and we submit that we have sufficiently discharged our burden of proof in our current case.
Are you required to establish burden in this case?
We would submit that we indeed do have the burden of proof to prove statelessness based on the facts in this case, and thereby we have sufficient.
In this federal court? In this court, do you have a burden to prove?
Based on cases which mentions about Section 1E, indeed, usually the applicant would bear the burden of proof to prove statelessness.
Prove statelessness in the proceedings before the High Court.
Indeed, Yari.
Okay.
Before I begin, may I kindly confirm with this on the record that if I'm audible?
Yes, counsel.
Much obliged, Yang Arif. Our former Federal Court Judge, late Gopal highlighted that the court should keep in tandem with the national ethos when interpreting provisions of a living document like the Federal Constitution, lest they be left behind while the winds of modern and progressive change pass them by. Judges must not be blind to the realities of life. May it please the court, my name is Ng Chin Yang, appearing as the co-counsel for the appellant. I will be submitting on the 4 to 6 issue for the following 21 minutes. Yang Arif. Briefly speaking, regarding the 4 to 6 issue, we submit that, first, the word father in Part 2, Second Schedule, Section 1B and 1C to the Federal Constitution should be read to include mother in light of Article 8 of the Federal Constitution. Second, the courts can review the exercise of governmental discretion under Article 15 Clause 2 and 15A of the Federal Constitution. And third, the doctrine of legitimate expectation applies in the exercise of governmental discretion under Articles 15 Clause 2 and 15A of the Federal Constitution. To begin, we respectfully submit that the word father in Part 2, Second Schedule, Section 1B and 1C should be read to include mother in light of Article 8 of the Federal Constitution. We have two supporting grounds. First, Article 14 Clause 1 Para B, read with Section 1B and 1C, must be interpreted harmoniously and organically with Article 8 Clause 2 to give effect to the prohibition of gender discrimination. Thus, the word father should be read to include mother. Yang Arif, pursuant to Section 1B and 1C of the Second Schedule, only a Malaysian father is allowed to confer citizenship to his child born outside the Federation. The usage of the word father, but not mother or whose parents one at least, indicates that Malaysian mothers...
Counsel, sorry to interject. Let's just cut to the chase, okay? So the law explicitly the Constitution explicitly allow discrimination if it's provided in the Constitution itself, which is stated in Article 8 2, I believe, para 2. So can you just reconcile with this court on this issue?
Much obliged, Young Arif. We understand that gender discrimination may be expressly authorized by this constitution. However, we say that a higher standard is required for such authorization of gender discrimination. As pointed out by this court in the case of Lee Kuan Yew against public prosecutor, the provisions of the federal constitution, which derogate from fundamental liberties, must be construed narrowly. Therefore, as the authorizations of gender discrimination is the derogation of such right, then we submit that it should be interpreted restrictively. As a result, we submit that the different usage of the word father and parent is insufficient to amount to express authorizations. And
Counsel, can you explain to me how is it insufficient when both father and mother, these two pronoun, sorry, not pronoun, these two noun has a gender meaning behind it? How is
indeed,
it not clear enough for you?
indeed, Arif, it is our submission that express authorization should be done either by inserting it under Article 8 Clause 5 or through a non-obstant clause, such as Article 168 Clause 5 in the Federal Constitution, which states that Article 8 shall not invalidate or prohibit any provision of Sabah and Sarawak state law. And neither one of these has been done by the Parliament, and it is our contention that this gender discrimination on citizenship matters is not expressly authorized.
It's not expressly authorized, but they already use father in part 2 of the second schedule. So how is it not expressly authorized? Is there anything that you can suggest to this court to include, to make it more explicit?
Indeed, Arif, we understand that the intention of the framers by deliberately using the word father and not the mother could be argued or could be deemed as an authorization of such discriminations. And however, it is our submissions that although the legislative history plays an important role in interpreting and understanding this constitutional provision, it had to yield to the later legislative developments. We have to understand that when Section 1B and 1C first came into force, there was no constitutional prohibition on gender discriminations. And in the year of 2001, the Parliament has inserted the word gender under Article Clause 2 to prohibit gender discriminations. Hence, it is our submissions that following this amendment to Article 8 Clause 2, it was no longer relevant or necessary to hark back to the thought process or intentions or the deliberate use of the word father of the original framers of the Constitution in interpreting federal constitutions. And hence, it is our submissions that in light of the amendment made in the year of 2001, the word father should be read to include mother. And if we may further clarify our positions, even after the amendment to prohibit gender discriminations, the Parliament did not take any necessary steps to constitutionally legitimize the discriminations on citizenship discriminations on
I understand, Counsel, but this is the duty of the Parliament. It's not a duty of this court to read more into what has been specifically prescribed in the Constitution. You are suggesting us to enacting law now, Counsel.
Young Arif, we beg to differ. This is because we are not suggesting the court to amend the Constitution, because according to Article 159, Clause 6, amendment means additions or repeal. And we stand before the court today, only ask this court to apply its function, its interpretative role to read the word father into mother. And there is no substantive amendment to include or to amend the word to father, to mother or parent. And hence, it is our submissions that in light of the legislative development and also the role of this honorable court, we urge this court to read the word the word father to include mother under Section 1B, 1 and 1C, Part 2, second schedule to the federal constitutions.
So, assuming that if you were to do what you have just said, and then tomorrow Parliament pass another legislation to amend father to parent, so it wouldn't have any effect at all, because now the court already read father as parent. Is that what you are suggesting?
Yang Arif, it is our submissions that although this honorable court might want to decide that the word father should be read to include mother, it is still better for the parliament to make substantial amendment to amend the word father to parents. This is because despite the decisions of this honorable court, there might still be challenges the interpretations of these section 1b and 1c, and it will be a never-ending battles or dispute if the parliament never take any necessary actions. And the reason why we urge this court to take steps in today's proceedings to read the word father and include mother is because the judiciary acts as a check and balances to the parliament, and hence, since parliament has
any external jurisdiction precedents that can support your stance?
Yang Arif, may I seek further clarifications on what point that you are?
On reading.
On the point where whenever you have a gender equality provision in a document, no matter how you try to specify an identity and a gender, it will automatically means the other gender, because what you are suggesting now is whenever there exists a general provision on gender equality, you can't differentiate or can't distinguish gender anymore because you say there is gender equal. So whatever reference to whatever gender, whatever pronoun or identity, it will be the same because there is a gender equality provision. And this is on top that our federal the rights provided under Article 8 is a qualified right, not an absolute right. So my learned brother, I think he's asking you, is there any foreign precedents which support what you just submitted?
Yeah, right. We apologize that we couldn't assist this court on this point because there is only a few countries left in this world that discriminate against mother on the matters of conferring citizenship to a child born outside the federations, and hence, regrettably, there is no precedent for this court to refer to
Our counsel, maybe, is there any precedence which shows that father connotes a gender-neutral term?
Indeed, Arif, it could be seen in the case of Mahisha Sulaikha, which was, however, it is in the dissenting judgment that the court decided that, according to Section 2, Sub 92 of the second schedule, a masculine gender should be read to include a feminine gender. Hence, it is a cause in contention that the word father should be read to include mother. And
what's the name of the case again?
Mahisha Sulaikha.
Okay.
Which is decided in the case of in the year of 2022 by the Court of Appeal.
Okay, all right.
And hence, it is our submissions that by merely using the word father deliberately different from the other provisions, even after the amendment to prohibit gender discrimination in the year of 2001, the Parliament had failed to take necessary steps to constitutionally legitimize such discrimination.
Even the fact that Parliament is not amending it or taking any steps to amend it to change the word to parent, it means that the Parliament intend to have the word father there, right?
Yeah, right. We beg to differ. This is because it is our intent. It is tried that Parliament is presumed to know all existing law when it legislates, because Parliament does not legislate in vain. Thus, when Parliament amend Article 8 Clause 2 with effect that and expressly declare that there should be no gender discrimination in any law, Parliament is deemed to have intended it to apply all discriminatory provisions found within the Federal Constitution itself, unless the discriminatory provisions are legitimized via Article 8 Clause 5 or via a non-obstant clause. However, during the amendment in the year of 2001, if the Parliament is intended to continue such discriminations on citizenship matters, they could have taken a simple step to insert it into Article Clause 5 or just insert a non-obstant clause, but they never done so. Hence, it is our intention that by not constitutionally legitimize their intention to continue such gender discriminations on citizenship matters. The word father should be read to include mother in light of Article 8 Clause 2 and the amendment that they have made in this year. With regard to the fifth issue, Yang Arif, we submit that the court can review or scrutinize the exercise of governmental discretion under Article 15 Clause 2 and 15A of the Federal Constitution, considering Part 3, Section 2, second schedule to the Federal Constitution. This is because Section 2 of Part 3 of the second schedule does not absolutely preclude the jurisdictions of the court. Yang Arif, the appellate acknowledged that the wording in Section 2, Part 3, second schedule is clear to mean that government decision is final. However, we submit that it does not mean that the court is restrained from doing anything when things go wrong. As rightly pointed out in the case of Mak Sik Hong, this outer clause in Section 2 does not preclude the court from judicial review where there was an error of law apparent on the face of the report. The reason being, when a decision is stated to be final, it does so on the assumption that the decision is made in accordance with the law. Hence, if a decision made goes wrong in law and the error appears on the face of the report, the court will intervene. Justice Abdul Kader succinctly put, and I quote, the reason for the inroads into outer clause is that the courts constitute the channel through which the king's justice is dispensed on to his people and are accordingly the basis of the rights of the individual. The courts must therefore necessarily be the ultimate bulwark against the excesses of the executive. In short, we submit that Section 2, Part 3 of the second schedule does not absolutely preclude the jurisdictions of the court when there is a jurisdictional defect and error of law on the face of the report.
What is the difference between finality clauses and ouster clauses?
So, my apology, Aaron, may I see?
What is the difference between finality clauses and ouster clauses? You seem to use both of these terms in your memorial. I'm just trying to understand you.
Yeah, it is our contention that they are meant to be the same thing because when a clause is legislated to out the jurisdiction of the court, it means that the decisions of that particular provisions made under that particular provision is final. And hence, it is our contention that they are the same thing. And by saying that the decision is final and trying to out the jurisdiction of this court, it does not mean that the jurisdiction of the court is absolutely precluded. And if we may further clarify our positions, when speaking of outer clause, it is worth noting that the evolutions in our legal landscape, as our former colonizer British practices parliamentary supremacy, it is not surprising that there exists or existed quite a lot of number of outer clauses in our law, being their leftover. Yet we should bear in mind that in Malaysia we practice constitutional supremacy, but not parliamentary supremacy. Our federal constitution is clear. Article 4 Clause 1 says that the constitution is supreme and anything inconsistent with the constitution shall be void to the extent of inconsistency. This is especially so in the case of recent years where most, if not all, of the outer clauses are struck down by this court. Much headway.
How do you struck down an ouster clause in the federal constitution?
Yeah, it is not our contention that we are not arguing that the outer provision in the federal constitution should be declared as unconstitutional. However, it is our intention to bring the headway that has been made in our the constitutional jurisprudence to curate the fine balance between policy considerations on the one side and the adjudication and supervisions of the legality of state action by the judicial branch on the other. Hence, it is our contention that when
that is not the intention. You see, the legislator does not legislate in vain. So they intended it to be an ouster clause in the federal constitution.
Indeed, Arif, hence it is our intention that in light of this, the constitutional development in our country, we shall be mindful of this gradual shift from unfettered discretion that has
Sorry,
been.
can you pause for a while? I think.
Sorry, I want to just pick up the
yeah.
argument for the
Yeah.
Parliament does not legislate in vain. So applying it similarly to the present situation or the present provision that we are impugn provision, there it is an intended clause. There is intention to it, and the intended effect of it is to oust jurisdiction of the court when it comes to matters like this.
Young Arif, it is our intentions that it is my apology. It is our contentions that we acknowledge that the Parliament does not legislate in vain. However, there must it does not out the court, the jurisdiction of the court, absolutely, because if that is the case, then it would make our judiciary subordinate or subservient to the Parliament, because the Parliament has the final say to determine whether the court has jurisdiction or not. And we say that this is not the case. And hence, whenever there is an outer clause, the court or the judiciary still has the power to intervene whenever necessary. And if we further direct,
So what's the remedy? What is the remedy available when there's an ouster clause? For me, it seems to me there's only two. Number one, upheld it. Number two, strike it down. There's no in between.
in the Arif, it is our contentions that we should uphold it, but meanwhile, interpreting it in the way that it does not preclude the jurisdiction of this court absolutely. And this is rightly pointed out by this court in the case of Sundra Raju in the year of 2021. And in this case, this court discussed on Article 145, Clause 3 of the Federal Constitution, which provides that the Attorney General has discretion to institute, conduct, or discontinue any proceedings for an offense. Yet the court held that such exercise of power is not absolutely immune from judicial review and scrutiny. Indeed,
Yeah, I know, but is there an ouster clause in that particular provision?
Yeah, right. We understand that it is not an
Or a fidelity clause?
Yeah, right. This Article 145 Clause 3 provides that the Attorney General enjoys the discretion to institute.
Yeah, they are not the same. They are not the same.
We back to different Arif. It is our contentions that in our current case, Section 2, Part 3, Second Schedule provides that the government has discretion to decide the matters on citizenship and is not subject to the review or appeal of this court. And hence, it means that the similarity between Section 2, Part 3, Second Schedule and Article 145, Clause 3 is that both of them mean that the decision maker has the discretion to map things, and it is not open for the jurisdictions to intervene on their discretion. However, this has been made clear by this court in the Sundra Raju case that, well, they do acknowledge that the Attorney General, when exercising his power, not only takes law and legal principles into account, but also matters relevant to public policy and national security. Yeah, Arif, I see that my time has lapsed. Okay, but my seek for extensions of 3 minutes.
You still have
2
another
minutes
issue
only.
to go, right?
Yes.
5 minutes lah. May I propose, my little brother?
3 minutes. 3 minutes. Don't
Okay.
give too long. You gotta learn to manage your time.
Much obliged, Ari. Although the court do indeed acknowledge that the judiciary has no benefit to access to the public policy or national security documents, and some degree of judicial deference to executive discretions of the Attorney General is necessary, it does not, however, translate to complete surrender. This is because our system is built on constitutional supremacy where accountability, separation of powers, and rule of law take center stage. With all these considerations in mind, the court held that Attorney General's powers are reviewable based on the grounds of illegality, procedural impropriety, irrationality, mana fides, and so on. With that, we sincerely urge this honorable court to also balance the discretion grounded on public policy with the concept of accountability, separation of powers, and rule of law. And we submit that the courts can review or scrutinize the exercise of governmental discretion under Article 15, Clause 2 and 15A of the Federal Constitution, despite Section 2, Part 3, Second Schedule to the Federal Constitution. With regard to the sixth issue, we submit that the doctrine of legitimate expectation applies in the exercise of governmental discretion under Article 15, Clause 2 and Article 15A of the Federal Constitution. Yang Arif, The doctrine of legitimate expectation exists because there is a fundamental duty for those in authority to act fairly, as this duty is necessary for good governance and good administration. Therefore, as Article 15 Clause 2 and 15A give the government the discretion or authority to confer citizenship, the doctrine of legitimate expectation is applicable to them so as to ensure the government act fairly. Additionally, it is well established that the legitimate expectation is a relevant consideration that authorities must take into account when exercising their discretion. Hence, such doctrine is applicable under Article 15, Clause 2 and 15A of the Federal Constitution. With that, we submit that the doctrine of legitimate expectation applies in the exercise of governmental discretion under Article 15, Clause 2 and
Any case law for what you just said?
Indeed, Arif, for the principle that the doctrine of legitimate expectation exists because there is a fundamental duty to act fairly. It was pointed out in the case of Maylan, Valiant, Sdn Bhd, and Majlis Perbandaran Subang Jaya in the year of 2018 by the Court of Appeal. Therefore, we conclude that the doctrine of legitimate expectation applies in the exercise of governmental discretion under Article 15 Clause 2 and 15A of the Federal Constitution.
What was held in that case? You were saying that doctrine of legitimate expectation is applicable for to government when making decision. How does that work, and how does that work and apply in the case, the Subang Jaya case that you just mentioned?
In that case, for example, the government authority involved in that case is a land authority, and the court held that since the land authority has the
It's not
discretion,
a land authority, it's a local council, right? Majlis Perbandaran Subang Jaya. Land authority is Pejabat Tanah. That's land authority.
my apologies, Arif, can I seek clarification on that question?
You say there is a land authority. What was the party in that case? Is it Majlis Perbandaran Subang Jaya? I heard you mention Majlis Perbandaran.
It's Maylan, Valiant, Sdn Bhd.
Versus who's the local authority? Who's the government authority that you mentioned there?
Majlis Perbandaran Subang Jaya.
Majlis Perbandaran Subang Jaya is a local council. It's not a land authority. Was it?
My apologies, Arif. And if we may further clarify our positions, how the legitimate expectation applies to government authority, it is our contention that
How did the court apply in that case? In the Majlis Perbandaran Subang Jaya case that you just mentioned.
my apologies, Arif, we couldn't assist the court on this matter.
Okay. Can you come back to what you wanted to elaborate just now?
In the Arif, for example, a land authority who has the power to a land authority
Hello? Sorry. Please proceed.
Yeah, it has been decided by the cases that, for example, when a land authority as a government authority, when they want to do their duty or take any action, they are required to act fairly. And because this duty is necessary for good governance and good administrations. And with that, since the discretion is placed upon them to take action upon the discretions, and there is a need for the doctrine of legitimate expectation to apply in order to ensure that they act accordingly and act fairly to what they have promised or what they have done. And it is our contention that since Article 15 Clause 2 and 15A give the government the discretion to confer citizenship, hence the doctrine of legitimate expectation applies in order to ensure that the government act fairly on this matter. If I'm of no further assistance to this honorable court, the appellants would like to conclude our submissions with prayers for relief. Raja Azlan Shah, Chief Justice, once put, every legal power must have legal limits, otherwise there is dictatorship. In other words, every discretion cannot be free from legal restraint. Where it is wrongly exercised, it becomes the duty of the courts to intervene. The courts are the only defense of the liberty of the subject against departmental aggression. For the foregoing reasons, we urge the court to do justice without fear and favor, and pray that this honorable court will judge and answer the first to 6 questions of law in the affirmative. I thank this court for your time and indulgence. Much obliged.
I think when you're on additional time, you shouldn't do all that. You should just quickly conclude because you're on additional time.
Okay.
Comments. Who wants to go first?
I think generally it's fine. You all are able to perform well, and it's probably much better than what we've seen previously. Definitely, there's improvement. But I think both Nicole and Ching Yang should speak slowly, not to rush, and be a bit more candid with your response. Don't be too scripted in terms of the response. Just try to be as calm and as candid as possible, so it looks natural. Other than that, I think it's fine for me.
I mean, just to add from that, since
And,
Dinesh,
yeah.
I mean, just to add
Sorry.
on this, right,
Then
I feel
just
like
one more
today's-
thing.
Yeah, Dinesh, go ahead.
So one more thing, just be careful with what you say. Like you say, this is the basic interpretation. There's no gender discrimination prior to this amendment, or there's no this, no that. You got to be careful when you say that, because if there is something and people point it out, you looks like you've not done your readings. So you want to make a statement, try to measure your statement. There's little to none. It's kind of better than there's no. Okay, go on. Sorry.
No, I was just thinking. Just now Dinesh mentioned the part where, not scripted. I feel like today's performance, considering that Saturday you all will be submitting in person before 3 judges, right? I assume. Is this your first time doing a physical mode?
Yes.
Is it your first appearance right in front of 3 judges?
During prelim, we also have 3 judges, but
No,
prelim
I
is
mean, it's virtual, right? Like
Yeah.
in person mode. Is it your first time?
yes.
Okay. I feel a lack of human touch in your submissions. It's
Mm.
very robotic. I don't know how, Dinesh, maybe you can shed some light on this. I feel like I'm there listening to what you said, but you are just like a robot answering my question. Yes, you're answering my question rightly, but I don't feel like I'm connected to you. This is very important when it comes to in-person mood, because you need to establish that connection and the bond with the judge to make sure that they are interested and engaged with them throughout. I think as a starting point, what we always do is to make sure that the judge is following us. So like whenever we move from one, then we look at the judges, we have eye contact with them, really look them into their eyes and look at them and see whether they are satisfied with your answers, and then whether they are ready for us to move forward. And then whenever it's necessary, you can just say, I'm now proceeding to my second issue. Before that, do you have any questions? And then Arif, I note that I sense I see that you may have some question on this issue. Is there anything that I can clarify? What else? Just all these little things to try to connect with the judge, it personally, apart from on top of all your submissions. This is very important when it comes to in-person mood, because if you don't create that bond throughout your submissions, right? And if the other side manage to do it, they will mark them higher, because we are all humans. That the emotion side of things, you need to connect with the judge. I feel like that's what's lacking today, but probably also because it's virtual. But I just want to remind you that whenever it is a physical mood, what you need to do is goes way beyond than just answering the right question and then putting our arguments forward. It's also about connecting with the judge. Is very, very important. Take note of that. But I have to comment Qing Yang. I know that you're a respondent counsel, and is you switch side for semis, and it's definitely not an easy task. I think Teenage can attest to that. But I thought you did very well. But I feel like you're still not very familiar. But of course, it's just you only have 1 week preparation, so try to familiarize yourself with the case and all that. Because I see how well you did in respondent side, I think when you switch now to appellant, you can do better. For Nicole, I feel like after listening to you before the prelims now, and now that I listen to you after the prelims, I can see that confidence in answering the question. But it's just sometimes you tend to. I feel like when answering question, you tend to go beyond what was needed by the judge. For example, is my last question to you. I just simply throw one question on social economic factor. I just want to make your life hard, and then you tend to tell answer that actually invite more questions. You go into evidentiary threshold. Then you sort of like self-impose an obligation on your side that to say for us to do this we need to prove statelessness. Then I'm like okay. So do statelessness need to be proved before the federal court? And then you say, statelessness needs to be proved by a person who wants a citizenship. Then I sort of like, so now are you saying that are you self-imposing more obligation on your side? And also, federal court is not an avenue for you to deal with evidentiary matters of the case anymore. It's at the first instance court. So I don't think that answer is entirely right. But the point that I want to make here is try to avoid answering question beyond what was necessary. Okay. But I have to commend you. I feel like in terms of your confidence level, way more better from the prelims round, probably from the first practice session. And what else? I think the others ancillary comments, I put it in the comment box just now, and probably Putri, you can I hope you note down some those notes and then pass it to Chin Yang and also Nicole. What else? You wanna go first? CC?
Also, the other thing, right? Don't fight with the judge. Really, don't fight the judge. When I say your Sundar Raju case does not apply, try to find something else, because you will have some judge like that. They will come and tell you right in your face, bro, I don't agree with you. Once you can try to reconvince, but the fella said 2 times, maximum is 2, he said no again. Move on with life, bro. Don't fight. Don't fight at all. It's not worth it, because it's going to be a back and forth argument with the judge, because the judge seems to make up his mind.
Yeah. Another thing, whose idea to put opening statement? Just curious.
Yeah.
Is it recommended by some of the judges?
You mean mine
Opening
or Young's
both,
or
both of you. What's the rationale? What's the objective you're putting that opening statement there?
Because for appellant, actually, all the issues are very challenging for us. So we are trying to play with humanity a bit. I mean, to sentiment a bit.
Okay, if that's your objective, I feel like Chin Yang and Nico, when you both put your opening statement and closing statement, I don't feel the impact and conviction. You need to train a bit on that. If that's your objective, I can say today when you say that, I feel like you just say it for the sake of saying it. And also, I'm not sure whether these quotes are already finalized. I'm just slightly worried because some of the quotes that you quote is by some, I would say, controversial figure. If you met some judges who doesn't like that controversial figure, you invite some not so good impression. But I mean, again, this is not. Yeah.
Just be honest, like guys, Gopal Siram, not everybody is a fan of him.
Yep.
I mean, he's a legendary to a lot of people, but to a lot of judges and a lot of opponents, he is not a big. People are not very fond of him as well. So
it really depends on who are your judges.
What Chun Yong and I are trying to convey is very simple. You want to make an opening statement is okay. I think a lot of moods people do that, just don't get caught. Don't be surprised when someone says two things. Number one, he discredit the figure that you are quoting. Number one, and number two, they say, "Hey, bro, I don't listen. Move on to the argument." Okay. So if you want to make an opening statement, make it. But if somebody says that, your face expression don't change into like, "Oh, what the hell happened?" Okay, you just move on.
The
Yeah,
objective
that's
of yeah, yes.
no, that's the only risk that you will have. So yeah, go on,
Your weight it lah. I hear your objective, but make sure that your objective is something that add values and don't it won't be prejudicing your case.
Mm.
Okay. If the chances of it inviting any prejudicial effect on your case, then I don't see any benefit of putting an opening statement. But I'm just saying, but you all assess all these things, all right?
Mm.
CC, are you there?
Yes, I'm here.
Comments,
Okay.
comments. Yep.
Yeah, I think overall, both of you did a good job today. I think, like Shunyong and Dinesh already mentioned, they gave some like constructive advices. But for Chin Yang, actually my purpose was to throw you off the because I find you very comfortable. Like the last time I remember, also I find that you get quite comfortable. Like not to say when you're in your flow, I get it. You are very calm and composed. But so today I was trying to like throw you off the rail and see how you will react to it also. And yeah, like I think you did a very good job in terms of responding. But what is lacking, I agree with Shun Yung as well for both Nico and Qing Yang, that there is not necessarily a human connection. Like it doesn't feel like you're having a conversation with the badge. Rather, it feels like you're trying to deliver your points only.
Mm.
And because I mean, uh, when you're reading also, I was going through your submission, your memorial, sorry, and I feel like you're just going point by point rather than you're packaging it and try to deliver it in a conversant manner. If that makes sense.
Mm.
So try to have more human touch and try to maybe it's the way you speak also, especially for Nico. I think at the start also you are quite fast. Okay, so you have to take note of your pace, of your cadence on when you're speaking. And even though some even though the judge will throw you some wild card or some curveball, right? You try to also keep track of where you are. Because I find Chin Yang, just now when I asked you some questions, were you lost on where you want to come back?
You mean me?
Yeah. Were
Yeah,
you
because
lost?
it's a bit. Because it was, I mean, the question is a bit too much.
Yeah, because I can find that you were like, after I asked you all the questions, you were like, okay, so where do I continue? So you have to like really keep track of like, what's the next important point that you want to deliver rather than following script. Maybe there should be some, like, I think Dinesh did it before, so I saw him did it before, like there's some, he flagged key points on mind map that, which that he wants to convey during his turn. So yeah, maybe that would be helpful. Mhm.
Also, I just to add on from that, right? I feel like to work on that personal touch part, right? I think for previous years, every year Tun Sufyan finals they will stream it live one. Try to find back the video and just get a sense of how the courtroom is like, and then how the counsels engage with the judge. And I think most likely final judges will be either retired court judge or current court judge. So make sure you, in terms of decorum, you're really taking care of that. When I say decorum, it means that the way that you call the judge, Yang Arif, and then don't use the word you And
Mm.
what else? Don't stop them when they are saying something, and then wait for them to finish their question. Try to be really attentive for every single their conduct throughout the entire session. And then if you see they stop, they try to flip, also you stop. Some judges is
Mm.
very particular when a counsel, when he's reading and trying to refer something, and then the counsel continues speaking, they deem it as an act of disrespect against the judge. So depending on what judge you have, really, because mooting is also about flexibility. If you get court judges, decorum must be next level, and then really the entire session is just to try to please them.
Mm.
This is not debate. Debate you can fight with other side and then shout louder to other side. But when it comes to mooting, is the 3 person up there is not your boss, it's your God.
Not wrong.
They cough also, you need to say thank you. Okay, smile all the way. All this I don't need to mention already lah. And I tell you, it will be different than the virtual rounds because it is a physical mode. So look at the videos and see how the past teams they do that. And personal touch is one thing. I feel like Nicole, you need to work on that more. Chin Yang, you're all right, but I feel like with the limited time tomorrow, right, Chin Yang, you need to work a little bit on substance. Your oral advocacy is really good already, one, Chin Yang. Nicole, you need to work on oral advocacy, okay? The pronunciation on certain words also. Try to train with in front of mirror and all that. And again, I have to mention, I think CC and Dinesh will agree with me. We have coached many teams over the years. I've seen teams for more than 5. I think it's more than 5 years now. And trust me, I think this is a winning team. But you all have to put in an effort, and more importantly, trust yourself. Jin Yang, trust yourself, you can do it. I've seen many teams before, and I think this team can make it. So you need to trust yourself. Okay? Just one more day, try to build that confidence and give your best on Saturday. This is Tun Sufyan. This is not Namco. This is not Intermoon. It's a big ass competition. Okay?
Mm.
Make yourself proud. Make UCAM proud. You all can do it, one. Trust me. Okay? Any other words, Dinesh and CC?
I mean, agree 100%. Just be yourself, be confident, and just do your best. Really, there's nothing stopping you other than your own mind. So if in your mind you feel like you can do it and you feel like you will win the championship, then you will win it. It's just what's in your mind. Okay, so really that's the only thing.
CC?
I stand by what Chun Yong say also. I believe this is a winning team. Like based on the first training also and until today. So yeah, I wish you all the best this weekend.
Alright. Okay? Trust yourself, you can do it. You can win one.
Yeah, I
Do your
faith.
best. You wait for the
We
videos.
can record Chun Yong's. You can have just Chun Yong's recording play in your ear during the competition.
And more importantly, it's not about winning. It's about have fun and also enjoy the experience as well. You wouldn't get much opportunity to submit before all these senior lawyers, and right before the nice moot court in UM. So enjoy yourself. Do your best. It will be one of a hell kind of experience and opportunity, to have that. Submit before the judges. Okay. All right. Thanks everyone. Thank you,
Okay.
Dinesh.
Alright,
Thank you,
everyone for your
CC.
time.
No
Okay,
problem at
Thank
all.
you, Sung Yong, Dinesh, and CC for the insightful comments. We will do our best.
For sure you do.
Okay, all the best.
All right.
Let
See
us
you
know
guys.
if there's anything. Update us as well. We are excited to hear about your results.
Okay, we hope we don't let you down.
No, you're not letting us down. Don't worry.
The fact that you're going
All
to
in all,
semi is already a goddamn good achievement. Okay, come on.
Okay.
yeah.
Give yourself a pat at the back.
All right. Okay. Ciao, guys.
Thank you.
Get
Thank
some
you.
rest. One more day only. Okay.
Bye bye.
Bye bye. Thank you, guys.